Thank you. Good afternoon, Your Honors. I'm Danny McClendon. I represent the appellants. I'll refer to them as the Jwaad parties, if I may. I want to paint the facts of this case with a rather broad brush, in part because the record is extensive and I don't have time to go over each and every detail, but also because it's a little bit unusual because a lot of the record in this case was submitted by deposition and a number of the exhibits and the deposition transcripts were transcribed from Arabic. So there's a lot going on here. But I think that the parties, or at least counsel, agree on a few what I'll call salient facts. One, the seller's agent in this case played both ends against the middle repeatedly. He, and the trial court in fact found that it had been the seller's agent and not the sellers themselves who signed contracts in this case. The trial court correctly concluded that that was enough chicanery to force the trial court to rely upon the doctrine of ratification, but more on that in a minute. So the sellers, my clients, didn't know a lot of things that their agent apparently did. One of the things that they didn't know until either later or even after they were sued was that the buyer's agent and buyer and their seller's agent had made some material changes to the contract from when it was initially executed. There were 3 amendments, and those amendments changed things beyond just the closing date. There were different amounts of deposits to be paid, there were different parcels added, there were different terms and conditions included. And this included extensions, but one of the other things that the sellers didn't know, maybe ever until they got into discovery, was that the contracts had repeatedly been canceled by the buyer. There's no evidence that the sellers knew these things before the lawsuit got filed.
And so the notice of cancellation by the seller only went, or excuse me, by the buyer only went to the seller's agent.
As far as the record is concerned, I think that's correct, Your Honor. Because keep in mind, the sellers were foreign nationals, and as far as I can tell, don't speak English and never were here. They were connected, and this is from the brief of the appellee, they were connected to their agent through a rather circuitous route of family friends.
So the question about the responsibility for the foreign investment tax, that was always part of the original asset purchase or purchase and sale agreement?
I'd have to concede that the original document that it turns out was signed by the agent included a provision on the topic of the foreign investment, I forget the acronym, but the Foreign Investment Act, the one that was going to tax them 15%. I think it's also fair to say that all of the terms and the amendments really benefited the buyer. They bought more time and made arrangements that they wanted to make, geotechnical surveys, rezoning, some entitlements that they got attached to the land to breathe value into it. It's not clear from the record that there was any real benefit to the sellers in any of these amendments that they seemingly did not know about.
Counsel, I want to ask you about, in terms of your issues that you're framing, or how you're framing them, presenting them to the court with regard to issue 1 and issue 2. It seems to me that the substance of your argument with regard to issue 1 and issue 2 is very closely related in terms of what you're asserting. I'm wondering if issue 1 is really appropriately before us at all. In terms of with issue 1, you're challenging this decision as to the summary judgment motion. And my understanding is that this court has held in past cases that when a trial court denies a motion for summary judgment based on the existence of disputed material facts, the denial is not appealable after a trial on the merits. So is 1 and 2 are very closely related, I think, in terms of your argument. Is one really appropriately before us in terms of the challenge, the summary judgment motion, or is this really where we're moving on to issue 2?
I think the most candid thing I can say is that I don't need to win 1 if I win 2.
Okay, would you concede that 1 is not appropriately before?
To the extent case law says that I can't appeal a motion for summary judgment denial on disputed facts,
Okay.
then I'm not trying to change the law.
I got you, okay.
Now,
Well, was that how the summary judgment, didn't the summary judgment, I guess another way of looking at that, the summary judgment turned on a question of law, did it not?
well,
Not disputed material facts, or am I wrong about that?
I think the appellee claims that there was a disputed fact that prevented the entry of summary judgment.
Okay.
So
And that was the trial court's conclusion, right? That there were disputed material facts in terms of why the trial court just said it was denying the motion for summary judgment.
denied all of the various
Right,
positive
it said
motions.
there's disputed
Right.
material facts in this case.
But I don't think it makes much difference because there's a very plain and mercifully short statute here. 6213, 407, and 408. And even the trial court admits it applies because the trial court conceded that the only way it could enforce the contract and all the amendments was through ratification. But the statute says that to the extent there's misconduct of an agent, that the sellers are not liable for damages and that none of the common law remedies are applicable. And so, given that the statute is plain and simple and short, and that the seller's agent made multiple misrepresentations to both sides, but most importantly to his own clients, the sellers, my clients, I think the statute says there's no common law remedies available then.
Why isn't this carved out, though, under the language of the statute, unless the client or party knew or had reason to know of the misrepresentation? And hasn't the trial court determined that they, and rightly or wrongly, hasn't the trial court determined that they knew about this misrepresentation?
So that's, I don't want to trivialize it, but that's a little bit of a chicken and an egg problem because in this case, it's not clear that they knew until later about all of the misrepresentations that their own agent had made. Even the record as I understand it reveals that in the end, one of the sellers acknowledged that the extensions were okay, but not ever that they knew about all the cancellations and all the modifications of terms and all those other things that later surfaced as the discovery in the case developed. So at most, what you have here is one seller who, let's just say he was capable of binding all. One seller later said, we're okay with the extension, things happen. That did not, to me, reveal his awareness of all of the misrepresentations that the seller's agent made to the sellers, in which case I think the statute says that the sellers are not responsible for damages and unless and until the record reveals that all of the misrepresentations were known by the sellers, they can't get out from under that statutory limitation. So the other thing that I think this statute also means is that this argument about anticipatory repudiation and the futility of tendering probably also can't be applied because even the buyer admits that they were unaware that the sellers apparently had some problem with this 15% tax until after the closing date had come and gone. And so I think that when you take the statute that limits the liability of the sellers here, the record not revealing that they were aware of all of the misrepresentation, and the record revealing that the buyer didn't know that the sellers were having issues with the 15% tax because of their foreign national status, I don't think it was appropriate as a matter of law for the trial court to then go and apply common law remedies of ratification and specific performance and then rely also upon the doctrine of anticipatory repudiation. Which I'll wrap this up quickly. That also vitiates the order of specific performance, because I respectfully disagree with counsel and the buyer. The amount of fraud that is shot through in this case committed by the seller's agent should preclude the rather drastic remedy of specific performance under a contract that was modified as many times unknown to the sellers. Thank you.
May it please the court, Sarah Ingalls of the Nashville Bar, represent the appellee JRS Development LLC, probably refer to that entity as buyer today, and the appellant defendants as sellers. I'd like to start with a couple of factual corrections. I heard some misrepresentations of what the facts were below, and I don't think those were intentional, just to be clear, but want to make sure that those are corrected. First, that the trial court found that the real estate agent signed the contracts. That is not what the chancellor found. First, with respect to the original PSA, it's undisputed that all 4 of the sellers signed that document, or if they had one of their brothers or cousins signed it. They all agree that they assented to the original PSA. Now, as to the amendments, the trial court did not find that the real estate agent signed them. What she found was that it was more likely than not, that's the phrase she used, that the sellers didn't authorize their signatures to be added. Now, here's why I make that distinction. And this goes to another correction I want to make. This idea that there was fraud by the agent, and that was mentioned in the last sentence that counsel stated. The chancellor did not find any fraud on the part of the seller's real estate agent. The seller found that it was more likely than not, rather the chancellor found it was more likely than not the sellers did not sign their electronic signatures to the amendment.
And didn't get permission, right? And how is that not a fraudulent activity? And a realtor or an agent signing without permission, signing using electronic signatures that they're not authorized to use, and that sounds pretty fraudulent.
And the reason that the chancellor found that the signatures added to the amendments didn't rise to the level of fraud is because there was testimony at trial from the real estate agent about his communications with the sellers about getting those amendments signed. They originally signed the PSA wet ink, and he testified at trial that he was having trouble getting their signatures. And so in order to try to make that process more streamlined, he used a program called Quick Assist to view the document simultaneously with the sellers while somebody attached their signatures. That was his testimony, and that's why she didn't find it was fraudulent.
I want to turn your attention to the applicability or not of the statute of 6213-407 here. Unless the client or party knew or had reason to know of the misrepresentation, do we have findings from the chancellor in this case that cover the full gamut of misrepresentations in this case, or are the findings just as to specific aspects of the misrepresentation? So, for example, the chancellor here says they were all aware of the date change, right? The September date change. Does that really capture everything in terms of all of the changes that were occurring through the course of these amendments?
She did not make a finding. Well, actually, yeah, I have some citations to the record for the seller's knowledge of the material terms of the contract. Now, about the misrepresentation.
Or of each of the amendments? I mean, because the initial contract they signed, right?
Yes.
But did they know all of the material terms of the subsequent 3 amendments here? Or just the date change?
Yes, we have to piece it together, but the chancellor did. And that gets to also another factual correction, which is that this idea that the amendments only benefited the buyer, which I don't think is relevant anyway, who they benefited for purposes of this appeal, but they added earnest money, not only on 2 of the occasions, not every time, but buyer deposited additional earnest money. That was referenced in the text messages between Mr. Kitaiba. That's his first name. I mean no disrespect in referring to him that way, but there are 2 seller defendants with the same last name. So I'll refer to him as Kitaiba. Those messages, which have been translated from their original Arabic, are between him and the real estate agent, and I've attached them as an appendix to my brief. And he references, this is page 6 of the appendix, the new closing date, the 9/30. He also references the additional earnest money in those text messages. Possibly the best evidence as to this seller that he had knowledge of the terms of the amendments and that the amendment was signed, which goes to Judge Usman, your question about the misrepresentation, is the fact that on the first page of these messages, first page of the appendix, which was admitted as trial exhibit 27, is when his real estate agent sends him a photo of Amendment 3. And it says at the top, Amendment 3. His response was, not, what is this? Why is my signature on it? We're not going forward. His response was, quote, "Go ahead. Everything will be fine. Hopefully the sale will be handled by you." That was at the end of May in 2021, and then throughout June, July, August, he and the real estate agent continue talking about the upcoming closing. And in fact, on page 11 of the appendix, we're still in the text messages, the court can see a screenshot where Kitaiba sends his real estate agent photos of all 4 sellers' passports because that was required for closing. And the chancellor reasoned, well, why would he be sending his agent passports required for closing if he didn't think that there was going to be a closing because, as they now claim, they thought that the contract expired. Now, as to the other 3, I've talked about that, kind of refer to him as the lead seller because he told his agent, I represent all the sellers. Here's how we get to binding the other 3. And I think there are 2 different ways. One is that each of them ratified the amendments themselves directly. The other way is that those 3 other sellers gave Mr. Kitaiba, their brother or cousin respectively, express authority to bind them in the sale of this property. Both of those are supported by this record. And I'll point the court to the places in the record that support that. First, with respect to Kitaiba having authority to act on the seller's behalf, as to, well, let me back up and say, the sellers did not appear at trial and they testified through their deposition testimony. And each of their deposition testimony, which was admitted in excerpts, are trial exhibits. So first, as to Mr. Abdul Qadir Abdul Rahman, that's Kitaiba's brother, his testimony is trial exhibit 31. On page 25, I asked him, this is from his deposition, I asked him, did you authorize your brother to act on your behalf in the sale of the property? Answer, yes. Second, as to Mr. Alaa Jwaad, his testimony is trial exhibit 32. On page 28, I asked him, who did you understand was communicating with the buyer on behalf of you and the other owners? He said, only Kitaiba was communicating about this topic. Third, as to Mayan Jwaad, his trial testimony is Exhibit 33 on page 27. This is his talking about his communications with the real estate agent. He said, quote, he called once, or mainly he would call Kitaiba. He would not call Abdul Qadir, Alaa. He called Kitaiba to talk about doing a new contract or extending the contract. So that's kind of the first avenue where the court can find these other three gave express authority to Kitaiba, and Kitaiba ratified these three amendments. Now, there's another way the court can get to the same destination, and that's that the other three also ratified the three amendments. And here's the evidence of that. There are a couple of emails that were admitted as exhibits at trial in September 2021 that went to all four of the sellers. I asked all four of the sellers.
Was there a delivery problem with one of the sellers' emails in terms, maybe it's not this email message, isn't there a bounce back error message with one of those?
That's right, Your Honor. That was the email from the real estate agent, the September 8th email. However, that was Abdul Rahman, and he testified that he received the other email that I'm referencing, which is the September 13th, 2021 email from the title company. The court may have seen Ms. Hollingshead's name in the record. It was her title company that the sellers had hired to close the transaction on their behalf. But they just didn't read them. I asked Abdul Qadir, this is, again, his testimony is trial exhibit 31, pages 15 through 16. I said, would it be your general practice to open emails when you receive them? He said, only if somebody tells me I sent you an email. Alaa, trial exhibit 32 on page 21. He said, and this is when I was asking him about those September 2021 emails. He said, yes, this is my email. I only open stuff I'm interested to or I know it's coming to me. And Mayan, the final seller, this is trial exhibit 33, pages 36 through 37. I asked, you testified that was your email earlier, right? He said, yes, yes. I said, tell me what's going on in this email. Answer, I don't know. He sent this email. I didn't pay attention to it. And there is law to support the notion that a contract can be ratified by failure to respond or by silence. The party ratifying has to have knowledge of all of the material terms, and the record here establishes that all four of the sellers did. Those emails I was just referencing, one of them was from Ms. Hollingshead employee. She sent a whole list of attachments, and this is, let me give you all a site for this. This is trial exhibit, and the trial exhibits are volume 11 of the record. This is trial exhibit 23, September 13th, 2021 email from Kay Clark to all four of the sellers, and they all testified they got that email. She sent power of attorney form, which in the power of attorney form includes a legal description of the property. I know one of the amendments added a parcel. Technically, this 12 acres is made up of 4 different parcels. One of the amendments added the parcel. They had a legal description that includes all 4 of the parcels. They went to their email, ignored it. Power of attorney, ignored it. Date of closing, ignored it.
So day of closing here, there's no instructions to the buyer as to where to wire. There's no power of attorney executed, and it was for the sister that was going to handle it, correct? So in terms of what the buyer's looking at that day in terms of non-performance from the buyer side in that question, there's no instructions, and there's nobody who has a power of attorney to act on behalf of the sellers. That correct understanding of what's going on that day?
Correct.
Okay.
And This is where we get into,
Had a deed been prepared to transfer the property?
no, Your Honor. Ms. Hollingshead did testify live at trial. She was the title attorney handling the closing for the sellers, and she testified that she couldn't have done anything, including prepare a deed, or wouldn't have until she received a power of attorney. She also wouldn't have been able to prepare or complete the preparation of the settlement statement, which Mr. Randolph testified at trial, who's the principal and the representative of the buyer, testified that he was waiting for a settlement statement and wiring instructions in order to pay the purchase price. And it was not required for him to deposit the purchase price. This is the issue in issues 1 and 2 of appellant's brief. It was not required for him to deposit the purchase price. All that's required under Lafferty and other cases from this court is that the buyer or the party seeking to enforce the contract or sue for the other party's breach was ready, willing, and able to proceed. And Mr. Randolph testified he was ready, willing, and able to close that day. We submit the opinion of the Chancery Court should be affirmed, and we also ask for attorney's fees pursuant to the terms of the contract, which include a prevailing party provision.
Thank you.
Thank you.
I think we've covered it. I'll waive my 5 minutes.
Quick question for you, counsel, if you don't mind. What is it that the buyer was supposed to do here? So I'm thinking about closing, arriving, and you don't have wiring instructions. You don't have somebody on the other side with power of attorney. There's no deed prepared. What was the buyer supposed to do to meet his mutual obligations? I take your point in terms of mutual obligations, buyer and seller. What's the buyer supposed to do?
Wire the money, or at a minimum, present proof that he could have.
Okay, so who do you wire the money to if you don't have wiring instructions?
Your own closing agent,
Okay, so he was required
which he
to
had done
send
many times, he said.
So he had to send it to his closing agent.
I think his
in order-
case would be a lot better if he had.
Thank you.
Thank you.
Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time.
Thank you.
May be excused.